this one. Good evening, goedemiddag, avond, allen. Welkom bij de eerste bijeenkomst van klimaatnarratieven. Welcome to the first gathering of climate narratives. Today entitled the Intergenerational Climate Crimes Act. Just for context, Climate Narratives is a new public series that is initiated by the Society of Arts, de Academie van Kunsten, de AVK, in which artists enter into dialogue with scientists, researchers, lawyers, activists to propose new imaginaries of climate justice. This first edition of Climate Narratives is co-organized and produced with Framer Framed, platform for contemporary art, visual culture, critical theory and practice in Amsterdam. And our gratitude specifically to Annelies ten Have, Hans Sittrop of the Academy of Arts, the AVK, and the Royal Netherlands Academy of Arts and Sciences, the KNAW, as well as to Ashley Maum, Dinara Vasilevskaya, Josine Pieterse, and all of fellow organizers of Framer Framed for all of their organizational efforts. My name is Jonas Staal. I'm an artist. I'm a propaganda researcher. For full transparency, I'm a board member of the Society of Arts, the AVK, but tonight I'm here first and foremost as co-founder and clerk of the Court for Intergenerational Climate Crimes, the CICC, that I initiated together with writer, academic, lawyer and activist Radha de Souza. Tonight, de Souza and I propose to you a new climate narrative that resulted from the moment where our legal imaginary, through Radha's background and work as a lawyer, and my artistic imaginary met. And we want to discuss how we are bringing this new climate narrative into practice. And we hoped to do that with the participation of Davina Misijan, as well as Linda Steg. Davina is stuck somewhere nearby Leiden due to a local train public infrastructure collapse. And Linda is stuck in Germany because of a logistic train infrastructure collapse. Which means that you are going to spend this evening together with me, Higam Khalidi, as well as the chair of the Society of Arts, artist Lisbeth Bick, and Ashley Maum of Framer Framed. Our climate narrative, as I said before, is the Intergenerational Climate Crimes Act. And the Intergenerational Climate Crimes Act is an alternative legal framework to prosecute intergenerational climate crimes. And we have applied this Climate Crimes Act in our own Court for Intergenerational Climate Crimes, the CICC in Framer Framed Amsterdam, between October 28th and 31st, 2021, where we brought together judges, prosecutors, witnesses in public hearings to prosecute climate crimes allegedly committed by the Dutch state and Dutch registered transnational corporations Unilever, ING and Airbus. And we will show you now a short video excerpt that is narrated by Radha de Souza to give you an impression of the court, the framework, the space where the Intergenerational Climate Crimes Act has been put into practice. It's about 4 minutes.
This is the Court for Intergenerational Climate Crimes. This is the court where pasts, presents, and futures assemble. This is the court of human and non-human and other than human comradeship. Outside the court, non-human comrades are declared extinct plants and animals. Inside this court, they assemble as martyrs of the crimes perpetuated by states and transnational corporations. They are our ancestors who sit by our sides, comrades with whom we hold hands, pause, leaves as we charge the corporations and states responsible for the destruction of their worlds and ours. Fossils are present amongst us. For millions of years, our ancestors, animals and plants, lay buried in the recesses of time until modern states and corporations violently excavated and extracted them to burn our futures. This violence leaves generations of animals, plants, fungi, protists, and monorans without resting sites and without life-sustaining inheritances from their ancestors. Humans too assemble at the court. They gather to testify against corporations and states, against ecocidal and racialized crimes committed over multiple generations, against the death form of racial ecocidal capitalism. The humans join their comrades as judges, prosecutors, witnesses, and jury to deliver justice to corporations and states for their intergenerational climate crimes, for numerous extinction wars against all species and against time itself. We future ancestors, we accuse, we bring evidence of what has been done and what is to be done. For that is the burning question of our movement in a burning world. We testify to violated pasts, presents, and futures, and we testify to defiant pasts, presents, and futures. We bring evidence of dying worlds and of possible worlds. We testify not only to the violence that has been done to us, we bring evidence of the living worlds, the life forms, the forms of life that could be, that must be, that were and will be. In the presence of all human and non-human comrades gathered at the Court for Intergenerational Climate Crimes, we proclaim living worlds, interdependent rights, intergenerational solidarity. We proclaim that regeneration of all life forms is the first principle of a law that constitutes shared comradely ecosystems and must be respected unconditionally to ensure deep futures for all, intergenerational, interdependent, regenerational.
So, watching this video excerpt, you have already heard some key concepts from the Intergenerational Climate Crimes Act as we have applied them in this alternative climate court. The emphasis not on rights, but on interdependency, not on individual rights, but on shared ecosystems. The rejection of linear time in favor of equality between past, present, and future. It's centering on regeneration, the desire of life to live in this legal imaginary. And of course, the expanded notion of comradeship. Comradeship as a relation, as a political relation that doesn't exist just between humans, but across human, animal, plant, shared ecosystems. For further reading on that specific concept of comradeship, you've received this booklet, Comrades in Extinction, that also includes an extinction archive, extinct animals, extinct plants that perished since the colonial period to the present. That makes a point. That emphasizes a point that Radha and me are trying to make through the court. That is that if we're thinking about the climate crisis, we cannot think of the climate crisis from the industrial period onwards. We have to think from the colonial period, as this is the first phase in which we started mass extinction of plants, of animals due to occupation and the theft of land and destruction of ecosystems. So if we're talking about the climate crisis, we are then talking about a crisis 500 years old. For a new climate narrative like the Intergenerational Climate Crimes Act to not just be an idea but to become reality, it also means we need to embody it. And in order to embody it here, we're not in the court now, but we are here practicing what such an alternative climate narrative can bring. We're going to need your help. So what I'm going to do is project some of the essential segments from the Intergenerational Climate Crimes Act. And I will hand out a microphone to go through the room. And our question is to you to share your voice, to lend your voice for a moment, to perform this climate narrative collectively, to go through some of its key passages. And with that, we're also asking your consent to proceed this evening, not through the climate narratives that you brought with you, but through this particular climate narrative that we are proposing to you tonight. So that means that we're going to move to the first slide. I'm going to test if this microphone works, and I will ask someone to begin this collective reading. Would you be willing to open? And then pass the microphone to the next person.
An act to abolish intergenerational climate crimes, to establish intergenerational relationships of solidarity and comradeship among human and non-human species.
An act to establish the Court for Intergenerational Climate Crimes and propose measures to remedy the abuse of intergenerational and interspecies relationships in the past by certain persons.
Be it enacted by the assembly of all those present in the name of the human and non-human ancestors, Mother Earth and the cosmos, and by the authority of those present in this assembly in their capacities as the ancestors of future generations.
Climate means the conditions necessary for reproduction of every species.
Humans means a concept-dependent herd animal that requires pre-existing concepts to negotiate the world around them and has capacities to make judgments and to review, reassess, modify, alter, change, and repudiate individual and collective behavior in a manner that may or may not be in the interests of future generations of humans and or non-humans.
Intergenerational includes all past, present, and future generations. For the purposes of this act, it is clarified that
the term intergenerational is not limited to a single step in the line of descent from ancestor.
B. The meaning of a generation is not limited to 30 years or other definitive numbers of years.
C. A generation may be of a different length of time for different species.
D. Intergenerational relationships include relationships between humans, between non-humans, and between humans and non-human species.
Legal entities are legal artifacts established by a group of persons with authority to do so for the purposes of limiting their environmental, social, and legal liabilities and responsibilities arising from their activities.
Non-humans means all other species in the past, present, or future that are living, have lived, or will live in the future.
It is clarified that non-humans include any natural phenomena like water bodies, including rivers, rivulets, streams, ponds, lakes, seas and oceans, rock formations including mountains, hills, ranges, caves, crevices and such. Plant species of any variety and any other life form that is subject to its laws, including birth, death, deterioration and regeneration.
Person means any living being subject to laws of life, in essence birth, life, death and regeneration cycles over periods of time as appropriate for each species.
Person does not include a legal person, i.e. legal artifacts that are conferred with human attributes by the fiat of law.
Place-based communities means groups of people who live in a place, including a region or area or locality, and by virtue of doing so constitute a community.
Could I ask you to continue?
Place-based communities may differ in size, numbers of people, and/or scale of operations.
Place-based communities may collectively determine the most effective ways of governing and discharging their responsibilities of guardianship over present and future generations, and their natures managing their communities and their ecologies consistent with the provisions of Section 5 of this Act.
An intergenerational climate crime is committed when a group of persons acting as a single legal person engage in acts of commission and/or omission, or engaged in acts of commission and/or omission in the past that harm or harmed, destroy or destroyed, violate or violated, or otherwise adversely impact or impacted the conditions necessary for the reproduction of any species, including but not limited to
acts of commission and/or omission in the past and/or present that harm, harmed, destroy, destroyed, violate, violated, or otherwise adversely impacted upon weather patterns in the short or long term.
Acts of commission and/or omission in the past and/or present that harm or harmed, destroy, destroyed, violate, violated, or otherwise adversely impacted upon weather patterns in an area, as a result of which the survival of non-human species become or has become difficult or impossible.
Acts of commission and/or omission in the past and/or present that harm or harmed, destroy or destroyed, violate, violated, or otherwise adversely impact or impacted upon relationships of mutual dependence and reciprocity between species or within species, human or non-human, and or introduced adversarial relationships between them.
Acts of commission and/or omission in the past and/or present that displaced people from places, fragmented communities, and destroyed cultures.
Legal persons as defined in Section 2.4 who engage in intergenerational climate crimes shall be dissolved and divested of their legal personhood.
Upon dissolution of any legal entity, the human persons acting in the name of the legal entity and aiding, abetting, and/or inciting intergenerational climate crimes under the Act, Section 3 of this Act, shall be automatically divested of their authority to act in the name of that legal person.
Such human persons, including managers, executives, officials, and other personnel who were at the time of dissolution employed by the legal entity, will be eligible to join a place-based community in any place subject to being accepted by the community on such terms and conditions as the community may impose.
Upon dissolution, any assets of the legal entity shall become social assets and handed over to the place-based community affiliated to the place where the assets are located.
Place-based communities may determine how they wish to use, reuse, or not use the assets of dissolved legal entities in their places, regions, areas, or localities, consistent with the principles of ecological and social regeneration and restoration set out in this Act.
Thank you everyone so much for lending your voice in this collective reading and for collectively carrying the climate narrative that is central to this gathering tonight. Now we continue by presenting to you the first verdict based on the Intergenerational Climate Crimes Act that we have just read in the case Comrades, Past, Present and Future versus the State of the Netherlands that took place at the Court for Intergenerational Climate Crimes on October 28, 2021, overseen by judges Sharon H. Wen, Rasigan Maharaj, Nicolas Hiltjaard, and Rade de Souza. The full verdict you have also received upon entry, next to the Comrades in Extinction booklet. This particular case was brought to the Court for Intergenerational Climate Crimes by Bart-Jaap Verbeek of the Center for Research on Multinational Corporations, also known as SOMO, who complained that the State of the Netherlands has committed intergenerational crimes against humans and non-humans by developing bilateral trade agreements that were designed to help transnational corporations to expropriate and appropriate natures and cultures around the world. Bart-Jaap Verbeek argued how the Dutch state has established itself as a conduit state for transnational corporations and financial institutions. Following the testimony of the prosecutor, we heard witness testimonies, amongst which from Sukherel Dugersuren of the organization Oyu Tolgoi Watch in Mongolia, who testified that bilateral trade agreements signed between the Dutch state and the state of Mongolia enabled the corporations Rio Tinto and Turquoise Hill Resources to mine for copper and gold, leading to life-threatening water scarcity and soil poisoning. The court heard witness Marcela Oliveira of Blue Planet Project in Bolivia, who testified that the bilateral trade agreement signed between the Dutch state and the state of Bolivia enabled heavy water extraction by Bechtel Corporation, leading to water scarcity for communities in the Cochabamba region. Finally, witness Alfonso Lopez Tejada, president of Acodeco Spat, a Cucama indigenous federation from the Maranon River in Peru, testified that the bilateral trade agreement signed between the Dutch state and the state of Peru resulted in the extraction of fossil fuels by corporation Plus Petrol, resulting in the destruction of local ecology, including the livelihood of First Nations in the Amazonian regions. Today, the Court for Intergenerational Climate Crimes will deliver its verdict in public. As I mentioned, all of you received a copy of the verdict upon entry. You can review the entire hearing, including testimonies and evidence of witnesses and the judges. You can review the entire hearing, Comrades Past, Present and Future versus the State of the Netherlands, as well as witness testimonies, evidence of witnesses, judge examination, and the Intergenerational Climate Crimes Act in full on the website of Framer, framed in the section Public Hearings, Court for Intergenerational Climate Crimes. To declare the verdict, I now pass on to writer, academic, lawyer, activist Rade de Souza, author of What's Wrong with Rights, author of the Intergenerational Climate Crimes Act, co-founder and chairing judge of the Court for Intergenerational Climate Crimes.
Good evening, everyone. It is my pleasure today to announce the verdict on the first hearing that took place on 28th of October. The judgment is before you, and Section 1 of the judgment is about the parties before the court. If you have been to a court and heard cases, you will know that case begins with who are the parties, and Section 1 discusses that. Section 2 is the charges that were brought before the court, and it has been summarized very briefly by Jonas Stahl. Section 3 is a summary of the evidence, and if you need the details of the evidence, you can look at it in the website and you will find the entire evidence that is there can be for viewing on the Framer Framed website. So sections 11, 12, 13, 14 are summaries of the 4 witnesses, 1 prosecutor, 3 witnesses. Section 15 is the summary of evidence presented by the defense, which is a section we included, but the defense did not appear. So we had to decide what to do. So we thought we would include in the judgment the kind of questions that we would have liked to ask them had they been present. Yeah? What would we have asked them? And one of the questions, some of those questions deal with how do they reconcile their role as an administrator and their role as a human being. And this is a contradiction that exists in people who work for large institutions. Where do I stop being human and responsible to my communities and my societies? And where do I enact the role that my job description gives me? So that's the kind of questions we would have liked to ask. Unfortunately, they were not present, so we could not ask them those questions. So I will now move on to part 4 of the judgment, which is on interpretation of the Intergenerational Climate Crimes Act. Now, this is the first case brought under the Intergenerational Climate Crimes Act 2021. Interpreting and applying this act to the facts before us without the aid of established rules of statutory interpretation, case law, and conventions has involved many challenges. Writing this decision has been a big learning curve for the members of this court. Members of this court are humbled by the trust that the deponents, the members of the jury, and the administrators of this court have bestowed upon them. We had to decide on questions of terminology in the course of interpreting the Act. Questions about terminology. So the first question was about using terms like complainant, defendant, prosecutor, accused which we find in normal courts. This court considered the appropriateness of using terms like complainant-respondent, plaintiff-defendant, and prosecutor-accused. The summons issued to the parties used those standard terms, and during the hearings, the deponents gave evidence were referred to as prosecutors and witnesses. I'm reading from paragraph 16.2.1. But that should not stop this court from asking whether certain terminology used in courts established by the state of the Netherlands should be adopted by this court as a matter of course. Are we going to follow the same term in language that the normal courts follow? In a civil litigation before courts established by states, such as the state of the Netherlands, the terms commonly used for those who bring cases to courts is complainant and respondent, or plaintiff and defendant. Complainants refers to those who complain to a court about breaches of entitlements, whether under statutes or contracts. And defendants, the person who refute those entitlements and contractual claims. The four persons who brought their cases to this court are not complaining about breaches of statutory entitlements or breaches of contract that are individual and personal to them. The terminology of prosecutor and accused is typically used in criminal offenses, which are broadly grouped into two classes of crimes: crimes against persons and crimes against property. The deponents in this case do not accuse anyone of bodily harm to themselves or offenses against their personal and/or corporate properties. To be a complainant or a plaintiff, the litigant must first concede to the authority of the Dutch legal jurisdiction and the authority of the state to make laws. Those who have brought this case before us claim that states, like the state of the Netherlands, cannot be allowed to act as the final arbiters of certain matters concerning the futures of species and life on this planet. The question of whether or not the deponents are complainants, defendants, or prosecutor accused invites consideration of two further questions. First, what were the natural persons who brought their cases to this court seeking to do? Second, why did they come to this court and not any other court for justice? We address both questions in turn. So the first question about terminology of complainants, accused, etc., is you have to accept the authority of the court and you have to make those claims within the bounds of statutes or contracts in order to be a case. Whereas we say there are certain matters that go beyond the authority of any state, including the state of the Netherlands. And that is about the existence of species and the fate of this planet. The Court for Intergenerational Climate Crimes is not a state-centric court. It is neither established by any state nor administered by one. This is a court established by the comrades of the Netherlands, by which we mean those inhabitants of the Netherlands who seek intergenerational justice for all creation. This court is creation-centric. It includes humans, non-humans, and everything else that is part of creation. State-centered courts are established to enforce a regime of rights. Rights create entitlements for right holders. The state determines who is entitled to what and how much. For example, states decide which indigenous people are entitled to land and how much land, and who is entitled to disability benefit and how much. States establish courts to decide disputes about the entitlements that it has apportioned to different social groups under statutes or contracts. The idea of justice in state-centered courts is narrowed down to breaches of statutes or contracts affecting individuals or groups. The remit of a creation-centered court, such as this one, is cognitively wider. Creation-centered courts are established to recognize the life rhythms and life cycles of creation and to direct human species to organize their lives consistently with the principles of interdependency, intergenerationality, and regeneration of all creation. Creation does not apportion entitlements to this or that person or group, or to this or that resource or commodity or service. Each creation is endowed with its own properties, its own sensibilities, and its own purpose, and its own rhythms of life and regeneration. The idea of justice in creation-centered courts, such as this one, is also cognitively wider. Justice in a court such as this one is intergenerational in the sense that everything in creation must be able to exist first and foremost and be able to reproduce the conditions of its existence for the present and future generations. A person bringing a case to a creation-centered court does so not for personal group benefits or to enforce a contract or statute, but they seek some truth about creation that has been lost or forgotten or deliberately discarded and or disrespected or abused. This is exactly what the persons who have knocked at the doors of this court have done. In different ways, from different places, they see that the majesty of creation is forgotten, deliberately discarded, disrespected, and abused. They see that the worlds for all creatures, including human beings, destruction and devastation, including human beings, are encroached upon and enclosed by creeping death, destruction, and devastation, as stated clearly in the evidence of comrades Dugarsuran, Oliveira, Tejada, and Separa in paragraphs 11, 12, and 13. The meaning of crime, I now move on from civil to criminal actions. The meaning of crime in state-centered courts revolves around bodily injuries to individuals or damage to individual or corporate property. The meaning of crime in a creation-centered court revolves around the destruction of the conditions of existence and the conditions for reproduction of life for all creation. It is not limited to what a state chooses to define as a crime. The images of many extinct species were present in this courtroom throughout the hearings as witnesses of past crimes against creation. States are and have always been complicit in the extinction of species on intergenerational scales. A state-centric court cannot be expected to address crimes against creation. For the reasons discussed above, the court finds that those who have brought their cases to this court are truth seekers, not complainants, not accused, not respondents, but they are truth seekers and not complainants or prosecutors. So the next court goes on to consider why the truth seekers have brought their cases to this court and not to any other. Firstly, this is the only court that is established for the explicit purpose of addressing crimes against creation. We don't know any other court that actually tries crimes against creation. The aims of this court are to abolish intergenerational climate crimes, to establish relationships of solidarity and comradeship amongst all species, and to remedy the abuse of intergenerational relationships in the past by certain persons. I will skip on to the reading of the section. The next one quotes section 27A, which we have read already, and go on to section 16.4.3. Secondly, there is no other court that is established to investigate the truth behind legal personhood. All courts, to the best of my knowledge, take legal persons as given. All four truth seekers have brought their cases before us that involve crimes against creation by legal persons, masquerading as real natural persons. We know that as legal artifacts, these artificial and unnatural persons cannot walk, talk, make decisions, or execute them. How do these artificial, unnatural legal persons behave or take responsibility or make decisions? Even more importantly, how and why do millions of natural persons around the world have faith in legal persons and believe that they can actually think, feel, and behave like natural persons? Why do they believe this even when they see ever more death and destruction caused by legal persons on a daily basis? These are the truths of our time that need investigation. State-centric courts are adversarial in nature, where the parties must compete to prove or disprove certain facts. Facts are not the same as truth. Indeed, creation's truth is often the casualty in adversarial judicial proceedings. Besides, fact-finding exercises in an adversarial system favor those with money and resources, authority and control over institutions. We heard from Comrade Tejada about the time and money they had to spend to publish reports and facts that everyone knew about which they had been complaining for 10 years and no one took notice of. The truth seekers have come out as losers in state-centric courts. They are losers because their adversaries are not real natural persons that creation has created. Instead, their adversaries are legal persons created by states. In other words, they are artificial entities. We have seen from the evidence we heard from Mongolia, Bolivia, and Peru, and the Netherlands that all four truth seekers have taken their cases to state-centric courts and to court-like consultative mechanisms set up by states and state-like institutions. We saw that neither the transnational corporations and financial institutions nor the state of the Netherlands paid much attention to the truth seekers and their evidence about the abuse of creation. Instead, they corrupted the laws and judicial systems in Mongolia, Bolivia, and Peru, and disempowered those states by taking away their economic powers, what Comrade Verbeek called dominium, from their political powers, or the imperium. For the aforesaid reasons, this court finds that truth seekers had good reasons for bringing their cases to the CICC and the comrades of the Netherlands. I now go on to talk about the legal personality and the problem and interpreting the act on that one. The court had to consider the use of vocabulary developed by state-centric courts and also whether that language has the capacities to communicate the concepts and thinking that inform a creation-centric court such as this one. The language of legal persons and words associated with legal personhood has fostered a way of speaking about artificial legal artifacts as if they are human. The truth seekers in this case spoke about what Rio Tinto, ADT, and Plus Petrol, and what the states of Netherlands, Mongolia, Bolivia, and Peru did or did not do. What international organizations like World Bank, ICCID, and others did or failed to do. Indeed, the members of this court too spoke about legal entities like transnational corporations as if they were human actors. We recognize the difficulties in speaking about legal artifacts in any other way. At the same time, the members of this court also recognize that the Act does not recognize legal persons. And we quote section 2427 of the Act, which I will skip over. Speaking about legal artifacts like corporations and states as if they were natural persons, when the statute explicitly puts them outside the definition of persons, requires clarification and explanation. Modern law in state-centric, now there's a little bit of legal commentary here. Modern law in state-centered legal systems are founded on what is called legal fictions in jurisprudence and legal theory. Lon L. Fuller, a noted scholar in jurisprudence from Harvard University, says this about legal fictions. And I quote, "Probably no lawyer would deny that judges and writers on legal topics frequently make statements which they know to be false. These statements are called fictions. Sometimes they take the form of pretenses as obvious and guileless as 'let's play' of children. At other times, they assume a more subtle character and effect the entrance into the law under the cover of such grammatical disguises as, quote, 'the law presumes,' or 'it must be implied,' or 'the plaintiff must be deemed,' etc. The influence of legal fiction extends to every department of juris activities. Legal personality, also known as corporate personality, is the foundational legal fiction without which there is no modern law as we know it. The legal fiction of legal corporate personality shapes the institutions of the state and economy. Legal fictions in modern jurisprudence came into existence in the 17th and 18th century when modern states as we know them today were established by European merchants, a section of the European aristocracy, and a section of European intellectuals. Over an extended period of time, for about 4 centuries now, these groups of natural persons, that is merchants, aristocracies, and intellectuals, established legal persons, and using legal fiats, they continue to establish legal persons and use legal fictions. They accord legal artifacts the status of natural persons and treat them as such in their social practices. We heard from Comrade Verbeek that special purpose vehicles were set up under Dutch laws as new legal persons, and from Comrade Oliveira about how legal personhood allows them to, quote, migrate, produce more corporate entities as if they were children and grandchildren of the parent entity. State-centered law has bestowed upon legal persons contractual rights, human rights, political rights, rights to organize, and created expectations of, quote, corporate social responsibility and social, moral, and legal, quote, behavior, as if they were human. The idea of human person no longer appears as fiction because modern institutions have embedded their thinking in language, law, institutions, culture, and every aspect of social life. Legal personality was created so that natural persons could use the artificial legal artifact as a facade to protect themselves from risk, avoid responsibilities for reckless actions, expropriate and appropriate natures and labors, ecologies and communities around the world on a global scale. Natural persons, either individually or in groups, are incapable of are incapable of death, devastation, and destruction, in the words of Comrade Tejada, on such an intergenerational and international scale without the intervention of legal artifact founded on fictional theories of artificial legal personality. In a creation-centered court, such as this one, law is based on truth and creation and reality at all levels of consciousness. This court does not accept that fictional concepts can be a foundation for social orders that respects all creation. Yet the members of the court could not have conducted the proceedings without using some state-centric legal vocabulary, even to challenge the conceptual basis for the language. We are of the view that by interpreting the Act, applying them to concrete cases, as we have done here, and building precedents and case law, it will become possible in the future to develop a language that articulates in more satisfactory ways the needs of all creation and not the profits of legal persons created by state law. Section 17, the paragraph 17 addresses the question, has the state of the Netherlands committed intergenerational climate crimes? And that section is based on the evidence and a discussion of the evidence, which I will pass on now and move on to paragraph 18, which is the main court's ruling. This is the court's ruling. It is a crime under the Act to give legal personality to an entity whose purpose is to seek personal and institutional gain at the expense of collective survival of all creation, including humans and non-humans. It is a crime under the Act to conspire with others to subsidize, support, or otherwise give succor through bilateral investment agreements or other means to an entity whose purpose is to seek personal or institutional gain at the expense of the collective means of survival of all comrades, humans and non-humans. By assigning rights to corporations and entering into bilateral investment agreements, the state of the Netherlands has violated and continues to violate the privileges granted by creation to comrades, human and non-human, in Bolivia, Mongolia, and Peru, and elsewhere in the world to exist and to reproduce the conditions necessary for their existence. The state of the Netherlands has breached the trust bestowed upon it by the comrades of the Netherlands by using the lawmaking powers it has inherited to commit intergenerational climate crimes. Now, the next is the court's orders. That the state of the Netherlands cease and desist from giving legal personality to corporate entities and revokes such recognition as has already been granted. That the state of the Netherlands cease and desist from entering into bilateral investment agreements that grant privileges and rights to corporate entities and enters into negotiation with other states to revoke such rights as have been granted. And lastly, I come to execution of orders. Court's orders must be executed. That the comrades of the Netherlands and elsewhere use all non-violent collective means at their disposal to organize to enforce this order. That comrades of the Netherlands and elsewhere use all non-violent collective means at their disposal to organize autonomous, self-reliant, place-based communities and develop short, medium, and long-term plans for the regeneration of ecologies and communities in their areas or regions and re-establish relationships of intergenerational solidarity with human and non-human species guided by the principles set out in Sections 6, 7, and 8 of the Act. Thank you.
In my role as clerk and co-founder of the Court for Intergenerational Climate Crimes, we hereby finish the formal declaration of the verdict, and we move on to a conversation about the Intergenerational Climate Crimes Act as a climate narrative, a conversation about the verdict that you have just heard, and this conversation with Rade de Souza and all of you will be chaired by Hisham Khalivi, a curator, I would say a multidisciplinary, interdisciplinary curator who has worked in Stac in Leuven, in Lafayette Anticipations in Paris, chief curator of the Marrakesh Biennial in 2014, amongst others. He is the director currently of the Jan van Eyck Academy in Maastricht. He was a public jury member at the Court for Intergenerational Climate Crimes in the case Comrades Past, Present and Future against Airbus. And he is himself the co-initiator of the Intergovernmental Panel on Art and Climate Change, so-called IPAC. Hisham, the floor is yours.
I don't know. Yeah, it's on. Thank you. I don't know. Let me just put this back. Hi. Oh. Here we go. All right. And my coat. So, hi. Can I put this up? There's the button to put this up. Amazing. Oh, wow. I love that. Thank you. Well, welcome. Thank you very much, Jonas. Thank you very much, Rada, for reading out the verdict. And thank you very much for inviting me, Frame of Framed, KNAW, AFK, Josine, Lisbeth, here in front of me. I'm going to improvise a little, because we don't have Linda here, and we don't have Davina here. And I prepared in relation also to them, in relation to their work. So I will be improvising and listening to what you have said and spoken about just now, of what we have spoken also before the event, try to glue things apart. And I would need your help as well, as public, because we have heard so much, and we have our own opinions. And this is a very important moment, a very important situation that we are in. And there are many questions that, that go to the realm of what culture and art, how art and culture relate to the idea of legal structures, of legality, of jurisprudence, and how we can use culture as an entity in order to foster new ideas and change, whether this be in a representative state or whether this be to maybe explain how we all are implicated and how everything goes through the lens of culture. This is something to be discussed amongst us and to see what that means. I think I was invited because also at the Jan van Eyck we organize and put the climate crisis at the center of what we do. We are a post-academy. We provide space and time to artists and designers from all over the world who reside at the Jan van Eyck. And given that these people come from all over, they bring with them a baggage that are related to conditions of life. They come, they reside, they live, they work, they eat together and with us. And with that, there is also an inherent positioning of what positions they start out with and how they come and how we host them. We used to say that at a post-academy such as Jan van Eyck, we treat everyone equal under one roof, which is not totally fair, because we don't always start from the same position. So when we get to a place like the Jan van Eyck, and we have to take account of these unequal positions. Most of all, when one thinks of what are the most important tendencies that could say something about what art practice and cultural practice would mean, we would say that the climate crisis or all subsequent crises that are stacking are of profound effect on what practice should be and can be. And this is also what we felt as Jan van Eyck that we wanted to put up front, to see if we could project ourselves into the future and to see what such academy that hosts people, first of all, it hosts human beings, it hosts people prone to context, prone to conditions, what kind of academy we could be in relation to the larger context and the conditions in which these artists and designers reside. So in that context, we started out with the ERC Intensive, which is a yearly program. And the ERC Intensive tries to make that relation between art practice and the climate crisis in forms of assembly. And this is possibly why we connect there, because in the last year's ERC Intensive, we, thanks to the idea of Bruno Alves de Almeida, who is our curator, instigated the IPAC, which is the Intergovernmental Panel for Art and Climate Change, where we asked the question, can culture be part of the assessment, of the assessing of the IPCC, of the Intergovernmental Panel of Climate Change? So in that sense, how do we inscribe culture into the idea of assessment? In this way, it looks very much like the CICC, and that we, like a party of the acronyms, as we called it, kind of the institutionalization of practice. What can art and culture mean in this? I think I am going to start with asking Radha to come forward, and then maybe we can start our discussion. Mm-hmm. And then after the discussion with Radha, we will have, well, discussion with Radha is also with the public, so we're trying to mix it. This is the idea. After that, we will have the opportunity as well that Lisbeth will speak 5 minutes, and you can also insert your questions in between if you like. Should I go there?
Okay, if you want to be there, that's fine.
Yeah, okay. Just gonna take a glass of water. Are you gonna? Ah, thanks. Maybe we help each other. Thank you so much. Yep.
Thank you.
Well, so the Court for Climate Crimes and the Climate Crimes Act are both cultural, artistic, and speculative tools that pursue the imagination as a space. Perhaps it's a negotiating space in which matters concerning, in this case, climate, environmental, and social justice can be thought through. Mm-hmm. By presenting the idea of the court, the act, the verdict, terms on loan from national and international legal structures, you were just also talking about terminology. The institutes involved are the implicated parties, the representative institutions such as Frame and Framed, the artists involved such as Jonas, you as a researcher, the public, etc., and the complexities of, and then with these, the complexities of alternative imaginaries can be investigated. So it's like a space that we create as a cultural artifact, right? Mm-hmm. Okay. Well, a main question that lingers here is, what do alternative and speculative climate narratives represent, and how do they force change? How do they alter policy making and behavior? So in this sense, how do you think, because that's for me sort of a question that hovers above us, is if this is a cultural artifact, in fact, we wish it to do something. Maybe that it enters the real world, that it enters the world where the real legal artifact exists. How do you negotiate this? How do you navigate this difficulty of the cultural versus the real, or the beyond the representative?
I think I'll start by saying that these kind of boundaries that we create between what is cultural and what is not cultural is hugely problematic. Because in these definitions, is Jonas only an artist and not a thinker in his own right? Am I only a thinker with no aesthetics? See, these kind of things are difficult. Of course, if you ask me, I can't draw a straight line. But, does that make one, an artist? Or maybe. So, I think we have to stop thinking in terms of these categories. Because everything exists in relationships.
Exactly.
So there is no art possible if there was no society. You have somebody to look at your art and admire it. And in my cultural tradition, for example, singers, musicians, they actually pray that they get a good audience. Because for a musician to have good listeners is so fundamental to their own music. To have a nuance. And there are temples that they actually go to and ask God to give them good listeners, without which they could not be. So I think one needs to start appreciating that there is aesthetics in every human being.
Exactly.
Yeah. And there is thinking capacity in every human being. And therefore, these boundaries are about mutually reinforcing. You get inspiration from looking at injustice in the world or whatever it is. And you feed back through your art, the whole inspiration to continue struggles. So it's not such a
difference.
The boundaries are not, as hard and fast as we like them to be or think about them.
But do you consider it as a cultural or an artistic artifact? Or do you go beyond that?
The CICC?
Yeah.
I would say it's much more than a cultural artifact. Yes, it's a court and it is a trial. And yes, it was hosted by an art institution. And yes, we had all the paintings. And yes, we are play acting. It's like when somebody is playing Hamlet in a theater, you don't jump on the stage and say, hey, you're not Hamlet. So nobody is jumping at me and saying, no, you're not a judge, right? But at the same time, the dialogues and the whole philosophy that comes through, especially Shakespearean plays, it's real. We all go away, feeling something about Hamlet or whatever. So yes, this is in that sense a play. I mean, it's a performance. But what informs that performance is real.
Yeah.
I mean, we are in a real crisis. None of us, and we are all troubled by it at some level or the other, and we all are looking for some answers to find a way out of this. And the whole inspiration for this court, at least, came from this idea that we were all going round in circles. We were all going round the same laws, we were looking out the conceptual world, and we were thinking of the, solutions within that framework. And we felt we had to go back to the basics because that conceptual world in which we live is not working. And we needed a platform to say that. And no other platform. I can't go to a court and say your conceptual world is not working. I cannot do that as a legal practitioner. When I wear my gown and go to the court, I talk about, how great the Constitution is. I mean, I have to do that, right? But it is not working. We know that.
But that's great. So you accept the conditions that you are in, and you make use of it even.
No, but this is stepping out of
enlarging your
that.
prospects.
This is stepping out of the legal the discipline, because art allows that space. But I'm sure there are many artists who feel very suffocated by the art establishment.
Exactly.
And they are looking for somewhere else to step out so that, he's laughing, that he can come and, say that.
I agree, yes. But even then, it's super interesting to see that the courts themselves are products of imagination, that the legal system itself is a product of imagination, that it's culturally mediated. So in that sense, it's almost like a way out for us as cultural practitioners.
Well,
not be bound by the threshold of representation in that sense.
I don't think that courts are a cultural thing. They may be informed by culture, but whose culture? And that is why in this judgment, we say clearly that in the 17th, 18th century, some European merchants, a section of the aristocracy, and a section of the intellectuals came together and established this. This is their imaginary. You know, the European peasants were out of this imaginary. They were all evicted from their land. That's why they went to the United States and North America and wherever else, because they were evicted from their land. And that is how you have cities and slums and, you know, all the Industrial Revolution stories. So it's not they who established it. So this is an imaginary of the merchants. And what we are saying is that the merchants' imaginary has brought us devastation and death. And we need to step out of being merchant ourselves in our thinking, just because we have been educated in that way, and start thinking in a non-mercantile way, not have everything having quid pro quo and, you know, what I call the accountancy logic to everything.
Yeah, thank you. I think it's interesting to tap into this, because there's a lot of things that relate also to our practices, also at the Academy, and where we are also looking more and more into moving away from the concept of individuation towards communality, and relationality. And that we have thresholds that keep us away from these ideas such as autonomy within arts practice or political neutrality. But also, if you look at contemporary political society at large, the idea of entitlement, you were talking about it just now. Entitlement seems to be connected to the idea of ownership instead of owing something or someone and being indebted. So it can also mean accountability or liability, which is nice if you connect it to litigation. These words give us a good start to work with when it comes to attribution of rights. Is this not counterintuitive that we attribute right to a river or a land, where this right is not the idea of being in debt of the river, that the river wants something back from us, but we are indebted, we are in relation to the river. We need to give back what we take. So the question here, is it in any way possible to find a way out in this legal framework that is not made for this? So the existing legal framework cannot account for what we are speaking about, the communal, beyond the individuation. Is there such a thing as communal rights, environmental rights, or communal indebtedness or environmental indebtedness?
Yeah, I think you've touched on a very basic premise for the Court for Intergenerational Climate Crimes, which is on the very idea of rights. And the idea of rights is closely associated to contracts. Yeah? And as I said, for a merchant, contract is the single most important thing. There's nothing that is more important to a merchant than contract, because everything has to be, you know, what you're buying, what you're selling, how much are you going to give me, when will you deliver? These are the kind of things that, and rights create a right bearer, so somebody who has something to give, and a person who can receive that, who's entitled to receive it. Yeah? And this is the language, the grammar, not the grammar of contracts. And rights are central to that. Without rights, there is no contract. And as I talked about the mercantile imaginary becoming the social imaginary, and this starts to happen around the 17th, 18th century, when rights then become, you know, the metaphor of for a whole social order. And I think what this does is it objectifies things. Everything has to become land. Land is something we exist on. It's a condition of our existence. But what rights does is it turns land into property.
Exactly.
Yeah? It turns nature into property. It turns human beings into labor force, which we then sell in the labor market. And we all the time worry, how is Brexit going to affect labor market? Not your problem, ours. but still, you get my point. But it is still, and therefore everything gets objectified, because if it is not objectified, it can't be bought and sold. So it is fundamental to a mercantile logic. And that is why you have philosophers like John Locke who come out and talk about the social contract. Mm-hmm. I mean, hey, who sat around the table and wrote a social contract? It was a mercantile metaphor, right? And they established the states, or what we call the modern state, because they were not happy with the feudal states. They established and that was a rights-based state. And this state was based on rights, but it evicted people from land. The enclosure movements in Britain and, mm-hmm. Danish peasants, German peasants, everywhere. People were thrown out of land. Slaves, slave trading, forcibly removed. That is how rights were established. And you cannot overlook that and just look at the normative promise that it makes. Mm-hmm. And say that this is. So I would say that, coming back to your question of is there a way of mediating it? Mm-hmm, mm-hmm. Is it like asking a merchant, can you give something to me free? Yes, they will give you something free once, twice. Yeah, but even when a merchant gives free, they want a tax relief for that. Even when a merchant gives free to God, then they want something back, give me more profits next year so that I can. So there is always that give and take. What we are saying is that way of living has brought us to a brink of extinction. Mm-hmm, mm-hmm. And we need to pull back from that mentality. Mm-hmm. So let's get out of that whole language of rights. Nature does not give anybody rights. It does not entitle you to anything. The air is there, you breathe it. The water is there, you drink it. You drink what you need. Human species sits on the top of the food chain, And I'm reminded of an opening line in the Rig Veda, which is supposed to be one of the oldest Vedic texts. I'm sorry, this is culturally completely alien to all of you. But the opening line of the Rig Veda is, life lives on life. And that's the first ecological principle. If life lives on life, then life has to safeguard life, because otherwise there will be nothing to live on. And because human beings sit on top of the food chain, it becomes our duty and our obligation to let all life live so that we can live. Mm-hmm. And I think this whole property mentality and the rights regime has come, we will cut a little bit of forest, but we hear what you're saying about environment, but we will keep a little bit, we'll plant some extra trees, which is never going to be the same teak trees that were destroyed to build railway sleepers, or which is never going to be the same. They take 800 years, 900 years to grow.
Exactly.
So,
yeah.
So that logic doesn't work.
But that suppose, what is your proposition in that you have to break apart that system first and build it anew?
Yes.
This is what I'm hearing.
That is why we talked about place-based communities.
Exactly. And creation at the heart instead of state.
Yes.
Exactly. Would you have an idea of how to bring this idea of Owen, which you find in decolonial theory, from Onin to Owen? Would you have an idea of how to bring forth this relationship that we have within this new paradigm? And are we using social imaginaries for that? Because we are not yet ready to break apart that structure.
I won't say we are not ready. What I will say is we are ready, but we don't know how to. Mm-hmm. I think vast majority of people realize that something is fundamentally wrong. And this, I wouldn't be exaggerating when I say this. In the global south, which is the third world, which I always say is 2/3 of the world, people know this. And they have tried many things, right? People here they know that something is not working. But I think the conversation needs to move to, and people have trying to make the existing system work. They have gone to the states, they have gone to the law courts, they have protested, they have marched, they have done all kinds of things within that. But then we come back to where we started. And that is where I think, in Global South, third world countries, we had national liberation movements, anti-colonial. These are big things, very big things in things. One can go back to history, all the socialist struggles. They all tried to do something out of it. But I think the question is, we need the spaces to be able to stand back and review what we have done so far, and to be able to reassess where do we go from here. And increasingly, those spaces are being shut out. For example, universities in the post-war era were kind of a liberal space where you got place where there were a lot of radical, critical, intellectuals, thinkers. With now neoliberalization of universities, those places are closed. So all social spaces, meeting places, we don't have places to meet.
So this is where we start.
Yeah, so you need to find, we had to find frame of frame so we could talk. This is what is happening. Otherwise, there was a time when churches, mosques, you could just have a meeting there. You can't meet people anymore. So this is becoming a crisis, and this is what is stopping us from, I think, asking those basic questions. What can we do? Why have we, what have we done well? What have we not done so well? What are the things that need to be reviewed and reassessed? And as human communities, this is a central part of human existence. That's why communities are so central to human life, because we are a herd animal, as the Act says. And for us, we have to gather as a herd to be able to see this is not taking us to a good place.
Exactly. And isn't there a difference between the idea of coalition building in the 60s, Pan-Africanism and all these things that happened, and now, where we have urgency and collapse as wind in our backs? Isn't there a difference?
There is always a difference, because we do certain things and we get some things wrong and some things, don't work. So the national liberation movements were big moments. Yeah, they tried self-determination, which is still a fundamental issue, but they thought that by forming another state, that somehow, we could get rid of whatever the problems were. But then their states started looking exactly like the colonial states that they disposed of. People here, in the Western countries tried for socialist struggles, and they thought socialism was a great thing. It was good, and there were big major movements. It has shaped the post-war generation and the post-war world in clear ways. But then things went in a different direction. So now is the time for us to sit back and think, what is this? What is good about this? So there are some people who throw the baby with the bathwater, and there's some people who don't want to throw the baby, so keep in the dirty bathwater. We don't need both those situations. And that requires us to rethink challenge our own imaginaries. Because we have to challenge ourselves. What does self-determination mean in this context if you cannot get clean water? What does self-determination mean if people have to sleep on the streets? And this is what, we need to come back to.
Yeah, exactly. Maybe I'll take it. Yes, we have a question. Yeah.
Thank you very much. I think there's a lot of people who are driven by stability. They want to have a world that can be predictable. They like the law, the language of law. And you have another part of people who are curious, who want to change, and who, maybe like the language of art. And here you combine these two, and I meet a lot of strategic ignorance. People don't want to hear about the disasters, and the more disasters you have, the more fear there is, the more people want to have more law, more predictability, stronger leaders. So in one way you address the language of law here. My question is, can the combination of art and law also inspire people to dare and be curious? maybe it's a fuzzy question, but I hope you understand.
Yeah. It's not a fuzzy question at all. On the contrary, you know, it is you need, you know, those kind of coming together to be able to transcend, you know, and to create new imaginaries. One of the purposes of doing this court was to expand and to stretch our imaginaries. And that was the main purpose. Yeah. So, and this is a way of stretching it. And by, you know, showing how limiting what you think is stability in the law is actually creating instability. You know, all the stock market rules that they are forming, they're totally, you know, it is an established, the deregulation things, you know, all the financial hedge funds, and they call it is we, the non-economists, the artists who think that law is stability. But if you talk to Bill Gates, for example, he's talking about creative destruction, you know, as the whole, because that's what the markets are all about. This will of the market, it's the most unpredictable thing. Mm-hmm. But we are willing to believe that the law that establishes those hedge funds and those derivatives and all those kind of things, which plays with our pension funds, which plays with our children's school funding, we are willing to believe that that is stability. But, you know, when we start saying that, this is not working, we think that, this art is disrupting. Art is not disrupting. Art is doing much less disruption than the hedge funds and the derivative of Fed, and Wall Street.
But it is a matter of view. And what would you say to the Forum for Democracy people if they vote for that and they want to have the tribunal, for instance? We spoke about it. On one side, we have here the climate court, which is an imaginary, let's say social imaginary. On the other side, we have the tribunal, which is the same, right? It seems to be a struggle or a culture clash or a war that is instigated where culture plays the part, the role. How would you?
Are you referring to like people's tribunals, Russell Tribunal, and that?
Well, I'm referring to right-wing views in which they feel that any attempt to subvert the existing system, the mercantile system, let's say, the neo-capitalist system, is in fact an injustice to them, right? You can flip the coin almost. And how do we account for all of us as a humanity with our different opinions and our different starting points and our difference? How do we do that? Because from our point of view as cultural practitioners, this seems to be logical. I mean, look at the nitrogen debate right now. The VVD just, you want to ask a question? Just 1 second. The VVD just, in their party meeting, rejected one of the propositions, for nitrogen.
For
the reduction of nitrogen in this country, because we produce a lot of nitrogen because of the state of our agriculture. It was rejected by the liberals, 51 to 49. This is huge, in fact. So I think the question of stability, and this is the same, that if we were to address the issues that we have, we need to do that communally, all of us.
Yes.
How do we address the different opinions and the different...
Well, obviously we need to do it collectively. Nothing is possible, and this is where we are collective beings. We are, and that is where the question of intellectual exchanges, questions of arguments.
Exactly.
The first thing I would say is don't be afraid of an argument. Because it is good that we have multiple views and things. It is good that we are able to sit around and we are able to come, because ideas only grow. Knowledge is a social creation, and it only grows when we interact with each other, when we, when we talk to each other, when we challenge each other. And that is how it develops and grows. And we should not suffocate it, we should let it grow. The key thing is to always identify what are your basic values. Yeah. In this court, we have said that the basic values are, first, we should be able to exist, and we should allow everything to exist. And that means anything that does not allow us to reproduce the conditions of life is a crime. So if you start with that, a basic premise like that, other things we can argue. We can argue about, what you should do in this election or that election. Those are very small matters compared to the level and the extent of the, the conceptual crisis that we are facing.
Yes. Would you like to pose the question?
A couple of weeks ago, I had a presentation about an architect, and he was flying around the world, and he was learning about inheemse stammen, indigenous communities. What will happen if we bring the people to this kind of place in the rich part of the world, when they come to The Hague, and we put them on into the power of the government? How do they look to our society, how we live, how we do, how we act, everything, and how do they do, act, live? And what can we learn from them? And what will happen if we put them here into the power?
I don't think that putting anyone into power, is really taking us anywhere. Because we all exist in our own spaces. See, the problem now is not that, of course, we have a lot to learn from each other, and we have a lot to learn from indigenous people, I would say, especially in the context of climate crimes, because they know the basics and they've still held on to the basics. They too have a lot to learn from you, all this dazzling technology. I was so dazzled by this lectern today. It just goes up. I mean, it's fabulous, don't get me wrong. But we all have to learn from each other. But the point is not to put anybody anywhere. This entire problem has come because of highly centralized governance of economies, of states, and it is getting more and more and more centralized, and more distant, therefore, from actual real people. And that is the problem with corporations and states. Because they exist, and as we said in the judgment, that this level of ecological destruction could not happen if there were not centralized institutions like corporations and states. Because how many, even if all Dutch people were bad people and did bad things, and they did it as individuals, they cannot bring this level of destruction. It remains localized, I mean, you take a simple thing. It's not like, there were no foot and mouth or animal diseases or whatever. But now you get bird flu, the whole world suffers from that. And that level of centralization is a problem. And the problem is therefore not to put anyone anywhere, on the contrary, to descale these institutions so that local people have greater control over their lives and over their ecologies and over their communities. And it is this scaling down that we need to, not scaling up, by bringing an indigenous person and putting them into those institutions. The institutions remain as they are. And we have tried this. Anti-colonial movements were about this. We kicked out, the British. We put our own Nehrus and Gandhis there. And what did they do? They did exactly the same thing. So it's not about putting people there. It is about looking at the institutions and seeing how can we build institutions that remain close to real people and real natural world, whatever is that. That is the challenge. So I have a thing about, keeping the institutions as they are and just changing the faces at the top. If I've understood your question correctly.
We have a chance to do a small round of questions.
Okay.
slowly we will have to move
That's fine.
towards closing.
Yes, well, thank you very much for your wonderful presentation again. I want to ask you a question about the legal person issue, because it's clearly also from your court order 19.1 that it seems to imply that all the legal persons should be disbanded. So I wanted to know, is that your position, that like the whole concept of legal person itself should be done away with? And the second question I have is about the community, because like the legal person, it involves like a kind of a collective with supposed will, your place-based community. So I was wondering if like, so my first question being, should we like disband all these legal persons? Second question is, does the community somehow replace the legal person in a sense of a kind of a basic legal unity?
Yeah. Good. Very basic questions. Thank you for those questions. As far as the legal personhood is concerned, I think one must recognize, I mean, historically, if anybody is into going to tell, I mean, I'm always, fearful of talking about some of these things, because then we have to get into the entire European history. You can say before modernity, there were legal persons. Churches were legal persons, universities were legal persons, your guilds were legal persons, so why not this kind of thing, etc. But there is a marked shift with modernity, and that is why I keep coming back to it. Is not, but modernity creates legal persons on the basis of fiction. The old legal person, I don't know if we can bring it back again. I don't think we can bring back the Catholic Church to what it was before, or those medieval universities, because that was another time and another thing. So, but modern legal persons, which include states, which includes corporations, they are based on fiction. And anything that is, if you have a social order that is based on fictions, it cannot deliver you the truth. And the truth of our situation today, in our historical conjuncture, is that we are heading to a disaster. An ecological disaster, a nuclear disaster, everything is staring, an economic disaster. You don't know what Wall Street will do next. And you can be left without your pension after working 50 years of your life. This is the disaster that stares at us. So this is because our social order is based on a fiction. And what we are saying is, let's move away from this fictional social order. And so therefore the answer is yes, all legal persons are problematic. Yeah? Modern legal persons, without going into the ancient ones. Now, to your next question on place-based communities. Yeah? I think place-based communities, because place is where the bonding between nature and people takes place. You live in a place, you are familiar with your river. Your river is not the same as mine. My river runs only for 3 months in a year, it rains. 3 months in a year, it's dry. Because I come from arid, your river runs all through the year. You get rain all through the year. We get rain 3 months in a year, and we live on that for 12 months in a year. So your river is different from mine. Your mountains are different. We don't have snow in our mountains. You have snow in your mountains. So I don't want to stretch the analogy, but that is the relationship that you need to form with your nature and your environment, and ask how you can put your labor, whether they are black people, white people, brown people living, that is inconsequential, because they too will have to form bonds with that, whatever the nature environment that you're living in. And therefore, I say, place has to come back to central focus if you want to shift away from, this. Otherwise, you are, building. And the whole logic of these institutions, whether they are corporations or states, is to deplace ourselves, to evict people from land and then put them into institutions, to take away your land and then to say, oh, now we can give you a job in a factory. This is the process of displacement and emplacement. And this has gone on for a long time. And that is why there is constant instability. And that is why I think bringing back place-based community, of course, it's a very elementary concept here. I mean, at the end of the day, this is an art project. But hopefully it triggers something imaginative.
Mm-hmm.
I don't think you would need legal entity. If you know everybody who's living in your neighborhood, you don't need a legal entity, or you may form rules, but that will be a negotiated rule, and we don't know what shape and form that will take. Yeah. For example, in Asia, across Asia, in the pre-colonial times, we had what were called the village economies. Yeah. And villages were the basic social unit. For example, taxation was a village can be taxed, not an individual. Yeah, that was a system. Sociologists now look at it and they call it the village republics. Maybe that village republic model we can bring back because we still have living memories of that. But you need to. I can't say what kind of place-based communities you can bring back. But we all have to look back into our histories, our cultures, learn from each other. Maybe you can look at our, village republics and see if you can replicate or learn something from us. Or, this is a process that has to, but we need to first recognize the primacy of place, because that is where human relations to environment is formed.
Yeah.
Yeah, thank you very much. I really enjoyed the evening so far, and I have great admiration for Jonas' style and your very bold piece of art. I'm a lawyer myself, so I take this very serious as a legal proposal. So I would also like you. I actually have like 30 questions, but I will limit myself. So the Intergenerational Climate Crimes Court is based on a non-linear concept of time. But I'm very much wondering about the remedies. So the remedy is to dissolve legal persons. And I would think that that is a forward-looking remedy, or it applies from now on. So I'm wondering, is there space for mourning also about those species that have gone extinct? Because I think that is also very much one of the inspirations of your project. And if I take seriously what this court would do, I think the charges would apply to almost every multinational corporation, perhaps to every state. So it would dissolve all those entities, which would in effect mean that we totally disrupt the existing social order. I think that might probably also be the reason that you chose this word comrade, which has this communist revolution kind of association. So, and then this brings me to my final question. So if that is the ultimate goal, and I think that is the consequence of this court, why was there not in the order of the court the dissolution of the state? Because the state is, of course, also a legal person, at least according to Dutch law.
Yeah. Okay, that's really a very good question, because we did have to consider this. I mean, the judges did consider, on the question, because we do define the state as a legal personality, and we do define the modern state in a certain way, and so on. But at the same time, the state's powers are inherited from its history. The state is not really, it's a historical inheritance, and it has powers to do certain things. But what we are saying is that it has abused the powers that it has inherited from history to then support and create these legal persons and so on. And therefore, the question of, it's a difficult one, and I will concede that question straight away, because the core driving energy for this place-based community is self-determination. Mm-hmm. Yeah? Self-determination. We decide what we want our destinies to be. And if that is the determination, then it is possible that the state as an institution will transform. Possible. Not necessary. It is possible that it will be so totally aligned that it becomes like a super fascist state, because if people rise up, then there is going to be a response, yeah, police powers, military powers, all those. And if that happens, people may be forced to reconstitute or rethink or reimagine these kind of institutional structures. We don't know. And so all I can say at this point is we need to be open to new institutions evolving from our struggles. Whether that will be, and maybe in some states, because the socialist revolutions were about states, right? They thought, get rid of all these capitalist blocks, and then we get hold of the state, and then the state will start serving the people. But that didn't happen. But the idea is still there, that, you know, somehow you get rid of these people and we can have a better society. And of course, the environment was not there, and women were kind of marginally there, a little bit, not so much. But, you know, that was the kind of world we're coming from. So the state is an interesting institution in that sense. The merchants usurped the old state, the feudal state that existed. And it was the merchants who transformed that whole feudal state by giving shares to the kings, by, you know, various other means. And I won't go into the history of how corporate power, East India Company or Dutch East India Company, all those things changed the character of the state. So that means that, can we also change the character of the state? We cannot say that definitively. It may change, it may not change. But rest assured that if we say that corporate personality is abolished, this state is going to be finished anyway. Mm-hmm. Because the power of the state as it exists today comes from those corporations. I mean, look at the American election money funding lobbying. You know, the kind of, now where would they be if they just had to fight as, you know, individual, honest individuals, instead of getting all this corporate money from, and the corporate lobbying that goes on. I mean, but we need to also then be willing to accept that the state as it exists today is totally corrupted as an institution, because it is set up with lobbyists and PR and, you know, all those kind of, and revolving doors which go, individuals who go from, you know, the state to the corporation, come back to the state. They're there, they establish the institutions. And we have dealt with some of that in the evidence here.
Yeah.
So,
what do you think in relation to this dissolvement?
Oh, I think it's terrifying.
Yeah.
No, I think it's terrifying.
Okay.
So I think there's a lot of, so the whole, well, the self-determination is, of course, also one of the core goals of a democracy. And so I studied how court decisions change society. And I think courts are usually, I think the proposal is in many ways fantastic. I think it should be achieved by politics, not by a court. I understand you chose a court. I have to think more about this. So this is not my definitive answer.
Yeah. It should be changed about politics. There is no, that's why the court says go and organize. Mm-hmm. That's how you execute the order. Go and organize collectively. So, you know, it is, yes, it is a performance here, but what it's asking you to do is to go and organize.
Exactly. I think we need to round off. I'm so sorry. Thank you so much, Radha.
Thank you.
But not before the final two invited respondents, but maybe you will want to respond
yourself.
The very, very last response to the respondents. We have two respondents. Ashley Maum from Framer Framed, who's also part of the research team and built the extinction archive that was just referenced, and of which you see some of the images that provide the vast 500-year evidence of intergenerational climate crimes. There are two options. Ashley, you can speak from the people with this microphone, or you can join behind this wonderful lectern for final statements and thoughts.
That's nice.
From the people.
Yeah, so as Jonas said, I was one of the researchers working on the CICC, and for that I had really the privilege to, and also in my roles working at Framer Framed. And I had the privilege of diving into the research on this Comrades in Extinction catalog. And one element that I worked really hard on was where we go through the threats that made these species extinct, which is essentially quotes from researchers on what caused their extinction. And something that's really stayed with me is that one of these quotes I found to read just simply, "This species extinction was forecast since its discovery." Which I think in that we can find a very upsetting resignation to a certain climate narrative, to certain narratives of power. And so I think what was sort of expected for me from working on this project, and probably also expected for everyone here from this verdict and from sort of cultural practitioners and artists who want to change things. And I think what we see in this act is a lot of desire to change society and to change our modern institutions very radically. But something I wasn't expecting was this change of terminologies, the section on the truth seekers, which probably isn't very important to everyone else here, but as someone who worked in the court, I know that we called these people prosecutors, witnesses, judges, which I think we are maintaining. So this is a very small point in the verdict, which I think is actually very meaningful because it shows a vulnerability within the court to admit a sort of misstep in something that we did ourselves in calling these people witnesses and prosecutors, and an ability to change a narrative. So I think that's something that was unexpected for me in the act, and that came, or in the verdict. But that shows a really important element of the people who are working behind the court. And I think that, just to stress that, I think that's something that the court should maintain. But also it does offer a sort of note for all of us that this ability to think self-reflexively and change, and just to do that without being so scared for looking wrong. Oh, I've been cut off. Yeah, but that's what I want to say, which is, of course, what we need people in power to do. So I think it's good that the CICC does it as well.
Thank you.
Elisabeth Beek is the second respondent, artist, part of the duo Big Vanger Pool, but also the chair of the Academy of Arts, Society of Arts, AVK, Academie van Kunsten, and thus legally obliged to stand behind this specific lectern in providing her response.
Okay, thank you, Jonas. Dear Radha, Hisham, Jonas, Ashley, and dear public, this is by no means a conclusion. I think what we are doing here is planting seeds, and I feel actually very humbled by so much eloquence, Radha, and also by the questions from the public. So this is even by no means a response, I would say, because I feel maybe not equipped yet completely, but I will try to say something that I prepared and that I think should be said, and maybe it repeats some of it of what has been said already by you and also by your questioning and so on. So there's really something going on when it is 45 degrees warmer in Antarctica than ever before. Around the world, we are affected by pandemics, climate crises, wars, injustice and inequality, theft of private data, dissemination of false information, streams of refugees fleeing war and desertification. And this is going to be more and more and more, I would say. Global capitalism leads to significant losses for citizens and a loss of rights all over the world. The struggle over definitions and implementation of democracy, and this is, I think, very important also in the context of this court, is symptomatic of the sometimes dramatic changes in the character of public life. These disruptions show how urgent the question of the public has become. Our conflicts have major consequences for the ecosystem of which we are all part. The message of the 2022 IPCC report is very clear. Climate change already poses great risks. For the time being, we here might think far from our bed. but these risks affect ecosystem and people and disproportionately affect the most vulnerable in the climate hotspots, and you referred already to that in the Global South. The burden on these areas and their inhabitants, who are mainly in the Global South, as I said, is disproportionate. We are colonizing the future, their future, our future, and the future of those who are not there yet. It is important that art and science talk to each other and reinforce each other to share the different kinds of knowledge, and that's also why we are here, I would say. For this reason, it's crucial that the AVK, Academie van Kunsten in Dutch, takes part in the Climate Sounding Board group of the KNAW. In this group, scientists and artists bring together different perspectives on the climate crisis. A monthly webinar with scientific insights from different fields of science under the title Climate from All Sides, Klimaat van alle kanten, is a first start for this collaboration. From the Academie van Kunsten, we contribute, and Jonas said it already, to these monthly meetings under the title Climate Narratives, a series of meetings that will take place from now on. This is the first one. In the Climate Narratives, members and non-members of the Academy propose the climate crisis from the angle of their artistic practice in order to help create new perspectives on the climate crisis. The German neuropsychologist, and I step a little bit back from what happened tonight, Ernst Puppel, he said, brains are lazy by nature. Although they are well equipped to register differences, they have a natural tendency to act conservatively if they are not continuously and constantly challenged and stimulated. Puppel is a great advocate of collaborations between artists and scientists because they can challenge each other in curiosity, for example. Puppel also argues that the arts and sciences are simply vital to resilient, elastic democracies. They make people flexible and agile. A visit to a museum or theater, or an evening like this, for example, is training the plasticity of our brains. A workout that is more than necessary. We need to be better equipped to deal with unknown situations when confronted with them. So it is in everyone's interest that science and art benefit from each other's knowledges and languages. And I'm not making propaganda here only. To be effective, we must also tell stories effectively. The words of Suzanne Moser, an American scientist in the field of behavior change, psychology and climate, who co-wrote the IPCC climate report, resonate here. She talks about the despair of climate scientists as they clearly see the disaster unfolding. In our society, reason has priority, but this orientation does considerable damage. She argues for a space where facts and imagination meet and asks what would happen if we acted with a head and a heart. The Academy wants to amplify what is happening. Identifying, putting on the agenda, researching, connecting and disseminating, contribute and build on how things can be done differently. How can we not feel so alone? What binds us? Where can we change something? Create spaces of opportunity or perhaps opportunism, in the good sense of the word. Where and how do we meet? Artistic and scientific freedom, inequality, climate crisis, all these things are not separate. They can only be understood in connection with each other. I see art as a verb, a process, performance, training, and as a cultural technique. An activity to turn existing knowledge against itself, to influence our ability to see, hear, feel things differently, to trust that ability to make public and to set our own conditions. To ask critical questions about what stories are told, how and by whom. To imagine and practice the possible futures that lie ahead and create stories that take place here, now and in the near future, and the far future as well. A model for moving forward that helps us to imagine how we will live together in a disrupted world. The power of art lies in its ability to make images visible and audible in all kinds of ways. The art is how we all make our forces more than the sum of their parts. Thank you.
think we are going to conclude. Your final thoughts on culture, resilience, and truth seekers. We have 1 minute for your both of your last responses.
Yeah. 1 minute. Become truth seekers, not complainants, not prosecutors. Become truth seekers. Think outside the box and organize. That's all.
Thank you, Radha. Maybe one last thing. I was just wondering, because you've worked on this for quite a long time, also together with your zine and everyone, a couple of years. How do you feel after these years? How do you feel? Yes. Are we backing you? Are we? And Jonas as well, and your relationship between you two.
This has been not, I mean, you know, I don't know where I found this man, but there you are. He found me, he says, but so it goes. But no, it has been absolutely amazing. It has been an amazing experience in a number of ways. Yeah. First of all, for me, you know, who has always worked in a global South context, to work in a very European context has been an amazing experience. And the love and the receptivity and, you know, everything that I have found. I've made amazing friends. Look at these people here, you know, really. I don't think this friendship is going away when the exhibition closes, right? And that has been, I think I'm stuck with Jonas for a long time.
That's good.
So, you know, it's been very amazing. But I think what I have learned a lot, I have learned a lot in terms of, you know, you academically, you read things and you critique and you write. I write on law and, you know, colonialism and law and imperialism and all of that. But to actually create something that people who are not lawyers can respond to. You know, it is about constitutionalism, but it's not constitutionalism. You know, it is about social contract theory, but it's not really social contract theory. So to be able to flip that law and critique of law in that way, that has been a very amazing experience. Yeah. And sometimes we work in our own little groups, or, you know, our professional identities take over our bigger identities. Lawyers talk to lawyers, artists talk to artists, and then we start living in a bubble, you know, what you were saying about scientists talk to each other. And I think what this conversation does is helps us to break out of that bubble.
Mm-hmm. Exactly. Yeah.
And that has been the most rewarding thing for me.
Yes. Jonas.
I fully second that. My note would be a very short note, because I'm very how do you call it? I feel always very dedicated to the social contract with the public, and we're moving over time. But I would say that for me, what I've learned most about the collaboration with Radha, and that also struck me again tonight, is the performativity of everything. So now we are in an informal conversation. We are no longer in the court. There were moments when Radha was reading the verdict. We are in the court. I mean, we had the public hearings, we had the prosecution, we had the witnesses, we had the evidence. We had 4 judges who worked for several weeks to debate how to interpret the Intergenerational Climate Crimes Act on this particular piece of evidence, on this particular testimony. So in its performance, or in the moments that you were willing to share in the reading of the Intergenerational Climate Crimes Act, then it is as real as we want it to be. And I think the quote that Radha made, or that the 4 judges made in the verdict, where a legal researcher or professor is quoted saying, speaking about legal fictions, I mean, that's true, right? Like these institutions, these narrative, they are only real, they're only capable of shaping reality as long as we are willing to give our legitimacy to them. When we retract for them and we say, not this court, our court, then it's as real as we acted into being. And this, I think, is where the question of organization, when Radha ended and said organize, this is where it comes down to. It's a question of imagination, it's also a question of organization. And to believe in imagination not as a fiction, but as a narrative that structures the possibility of reality.
Exactly.
I really want to thank Radha for your contribution tonight, for all the organizers, and for you, Hisham, for leading these beautiful conversations, for you for being willing to stay with us all along. There are drinks and there is food outside to continue the conversation. You're all very much invited, and hopefully we see you at the next Climate Narratives as the Society of Arts.
Thank you so much.
Thank you.